House Bill 893 is an effort to deal with the ongoing and well-documented problems with the second injury fund. It's an issue I know, Mr. Chairman, that you've spent a great deal of time over the years working on, and it's an issue that's really come to a head in the first quarter of this year. Second injury fund, just by way of background, was created shortly after World War II in an effort to encourage employers to hire returning vets that had some form of pre-existing injury. From that initial creation, the second injury fund has grown into what's in essence a supplemental insurance program for Missouri employers, and it deals with situations where employees have a combination injury, oftentimes that leads to a permanent and total disability. The problem with the second injury fund is one that is immediate now. We're no longer dealing with a situation where the second injury fund is facing insolvency or near insolvency. We have reached a point where the second injury fund is bankrupt. There is no longer enough money, plain and simple, in the second injury fund. There's no longer enough money coming into the second injury fund to pay the existing adjudicated obligations of the fund. In 2010, the second injury fund collected almost $41 million in revenue from all sources. It paid out $40.8 million. During the first quarter of this year, the liabilities of the fund have outpaced the amount the fund is collecting, which means that in about 3 weeks ago, the Attorney General's office stopped issuing payments to people who have an adjudicated award from an administrative court. In response to that, and I think a very predictable response, there's been a lawsuit filed in federal court that has asserted that the rights of those claimants who have adjudicated awards are no longer being handled, that their remedy is no longer adequate, which means that we are faced as policymakers with this very critical question. And that question is whether this body is going to deal with this issue, deal with it responsibly and in a way that protects Missouri employers and claimants, or whether we're going to let a federal court decide how this situation is handled.
We've talked about small jobs and moving and helping small businesses get started. So how is it reasonable for those people to get started with this surcharge of which they really had nothing to do with? I mean, does it make sense?
Right. Well, first, the very smallest of businesses don't have to provide workers' compensation coverage to begin with. But I think the second component of it is that what we're doing is really putting employers and those looking to open businesses on a more solid footing, knowing what their obligation is going to be going forward. I will readily admit that I wish we weren't in this position where we're having to ask employers to pay more. The reality of it is we're faced with the choice of allowing a federal court to decide what's going to happen to Missouri employers, or we're going to make the decision as a policy-making body. That's the question. The intent of the bill is to try to avoid allowing a federal court to decide and produce a bill that puts claimants and employers on the best footing going forward.
Mr. Chairman, members of the committee, Richard Moore on behalf of the Missouri Chamber of Commerce and Industry. We're on record in support of this bill, but we don't like the fact that we have to be here doing this. It is going to be difficult for our employers, and it's not something that we want to take on, but we have to. The fund is absolutely insolvent. I wanted to address a few of the things that was brought up in questions. However, you all have basically addressed many of the things that I was going to come here and testify upon. I've spent hundreds of hours on this issue trying to determine what are viable options for the state. And we're down to either a massive restructuring, which the Senate had a committee and heard that a few weeks ago, or get rid of the fund entirely, which is what this is. Neither option are good. There are approximately a $921 million tail as of today's cases. That doesn't count the 27,000 cases that are currently pending, and that doesn't count the 700 cases that are filed every month and will continue to be filed every month until the law changes. $920 million. It will take 40 to 50 years to get through this. A few of the things that were brought up that I wanted to touch upon, and I provided written testimony, and it goes into greater detail about many of the factors that you would likely want to consider. On the back couple pages, you'll see a graph about the revenue stream versus the expenses that I think is pretty interesting to take a look at whenever you're going through your evaluations. If you look at the blue line, you'll see the revenue since 2010. The red line on top of it is actual expenses. In 2009, as the representative said, the Attorney General's office cut off settlements, which provided short-term stability to the fund. It created revenue to pay the ongoing liabilities that were already adjudicated, but it caused this buildup of cases that are the 27,500 cases. If you look at the green line that continues, that is a conservative estimate of where we would be today if the revenue would be adequate to deal with the current existing cases. It has dropped significantly, and in fact, it has dropped the revenue has dropped 43.5% in 3 years. But the ongoing obligations, the liabilities, continue to rise. The fund itself is in a position where we have to make a decision. And the decisions that are before you and that I'll touch upon are to get rid of the fund. And what does that do? It shifts the existing claims out to the workers' compensation system. So it's dealt with in like manner as what the current primary and secondary claims are today. It grants certainty to the business community knowing what it's going to be, what the charges are going to be that we're going to be facing. And there's not going to be this sense of feeling that $41 million is enough revenue to go forward to provide all the liabilities for the case. We're under a false impression that there's enough. There's clearly not. It's almost double that to be able to adequately adjudicate the claims that are currently out there. The other options that you might hear, besides completely closing the case or closing the fund and fixing the fund, is to just close the fund but without having a financial fix. I would like to submit to you that is not a real option. It won't, in my opinion, it has very little chance of getting through the Missouri Senate, as I believe a filibuster would occur. It has very little chance of being signed by the governor if it were to get through both chambers, because it does nothing. It creates more cases. If it gets vetoed, it creates more cases. These 700 cases are going to continue every single month. And when we come back next year, we're not going to be dealing with 27,500 cases. We're going to be dealing with closer to 30,000 cases. And all of these cases are going to be filed and adjudicated under today's law, which allows injuries that are sustained, secondary injuries that are sustained, to utilize primary injuries that have nothing to do with work-related causes. Obesity, for example, is one component of a injury, a primary injury, that can allow you to get into the second injury fund. Employers are hurting today. It is not good for the economy is not good, and we're hopefully going to start seeing improvements. But these obligations go on for 40 to 50 years, and we need certainty.